Hi everybody, Armine Bazikyan from Bazikyan Law Group. This month I wanted to speak to you about genetic material and what it means to your estate plan, if you have any stored. So a lot of times people will nowadays choose to store their child's genetic material, meaning their cord blood or their stem cells, and they won't take into consideration or they won't give thought to what it means for their estate plan as far as taking the next step and deciding, well, what do I do with this stuff? What plans do I need to make for it if now I'm not around to manage it and pay the storage fees? So let's take a step back and talk about the process and then get to the point where we talk about what you need to do to properly plan for your child. So a lot of times parents nowadays will choose to store cord blood or stem cells when their baby is born. So they'll call up a company that they choose, and there's a ton of them on the market, and they will come and take the material away and they will store it at a storage facility somewhere. And then they'll continue to pay a storage fee annually. Some people choose to pay it for life. It just depends on your situation. However, usually you don't have contact with these companies other than them sending you an invoice to pay for that year. So at the most, they'll contact you once that year to pay your bill for the storage fee, for the annual storage fee. So a lot of times when a person passes away, whoever comes after them to take care of their kids has no idea that the material is being stored somewhere and it exists. So that's where the problem arises when it comes to estate planning. What I want to do is I want to make sure that the person that you've named as guardian for your child, as trustee for your child, is aware that you have cord blood stored in Arizona somewhere at a storage facility, and that if anything happens to you, they should continue to pay that storage fee and have access to that material to be able to use it for your child if the need should arise. And so because this is a relatively new area of the law, there isn't much instruction on how these companies can handle it. And so what's happening is that these individual companies are actually making internal procedures or putting in place internal procedures to address these issues. So depending on the company that you have your child's genetic material stored with, there might be a different procedure in place for how they handle it if something were to happen to you. So for example, CBR is a very common company that a lot of parents choose to go with. And what CBR allows you to do is they actually put you as the primary owner of the material since your child is a minor. So they will list you as the primary owner, and hopefully you've given them your spouse's information, the other parent's information, and they've listed the child's other parent as a secondary owner on the documents on their back end. And so what CBR allows you to do is they'll allow you to list a third and a fourth person. Now, my preference would be to list your trust as an owner of the property, of the genetic material, because that way whoever you've named as trustee will take control of it. But a lot of companies won't allow you to list an entity like a trust as an owner, and they prefer it to be, or they require it to be an individual oftentimes. But at the very least, you'll be able to list the guardian or whoever your trustee is as a third and then maybe a fourth successor owner of the property. That way, if something were to happen to you and the child's other parent, at the very least, they have contact information to be able to reach out to grandma, for example, and say, hey, grandma, this annual storage fee is due. You guys need to pay it so we can continue storing it. And you're the person that now owns this material, so you can choose to use it for the child if the need arises. So it just involves people, it just allows the company to be able to reach out to somebody in the family to kind of maintain the stored material and allow the child to make use of it if the need should arise. Now, if you pay, a lot of times these companies will have the option of allowing you to pay the storage fee for the lifetime of the child, which works out fine if you don't want to pay an annual storage fee. But again, even in that scenario, you still need to list, or you should list, a third and fourth owner so that they know who to give the material to and who's going to be in charge of your child so that they can use it properly. So it's a very new area of the law. There isn't much instruction legally on how it's done. So I would advise, if you do have it stored with a particular company, call that company and ask them what their internal procedure is for handling scenarios like that. Now, most of these companies at the age of 18, for that child that they have the material at, what they will do is they will automatically make that child the owner of his or her own genetic material, which is great. But even in that scenario, if you have an 18-year-old and you've stored material, they're now the primary owner. You should still have them list you and the other parent as a secondary and third. Just in case that child passes away and you could still make use of this material for a sibling. So I would advise you to contact the companies, and this is, whether you have an estate plan in place or not, you should still have a third and fourth and second listed on the ownership list of who owns these assets, just in case, to protect yourself and to make sure that the right person is in charge and the right person is contacted. Always update your information with these companies if you move. A lot of times they'll only have an email in place for you as a form of contacting you. So always update them with an updated email address as well as a phone number and mailing address so that they are able to reach you if they do need to reach somebody. That way, if you're not there and they're sending you mail and it's going to the right address, at least whoever has survived you and is taking care of your kids will have the information by mail to know that you have this stored in place. So update your information with these companies and make sure that you've listed a second, third, and fourth owner of the genetic material to ensure that they are not only properly paid for and stored, but that the person can actually access it and use it for your child or children if they need to. If you want to discuss this topic a little bit more, feel free to give me a call. Our office does provide free consultations, so feel free to take advantage of that. Hope to speak to you guys soon. Bye-bye.